The items from Itanagar bench for judgment, item number 1, criminal appeal jail, 5 of 2022.
Criminal appeal dismissed.
Item number
Obliged,
2, WPC 492 of 2022.
Petition dismissed.
Item from principal seat for delivery of order, item number 32, higher civil 3368 of 2024.
IA dismissed.
May I please your lordship? Lordship, I pray for listing of a motion, fresh motion matter on day after tomorrow, lordship. Deeply obliged, lord.
I have a similar plan, we are in transfer of position, so.
When?
It is final.
Okay. Yes, madam.
My lord, I would like to mention item number 14 and 15. That is for admission under order 41. My lord, this matter may come up after 2 weeks, my lord. I have some personal difficulty.
14 and 15.
14 and 15, my lord. I have informed the other side.
Okay. On the pair being made by Ms. B. Sodori, learned counsel for the respondent with consent from the other side. The matter stands adjourned to be listed after
2 weeks, my
after
lord.
2 weeks. Yes.
May it please your lordship. My lord, very in a difficult position, I am appearing for the ASTC, some state transport corporation, and IA is pending for the continuation of delay of a civil appeal. If I may pray your lordship to list it tomorrow, my lord, very urgent. Tomorrow, so many cases. Hearing matters already 30 cases. My lord, this matter pertains to the land of ASTC in Moran, Dibrugarh district, my lord. There are execution proceeding pending. They will remove everything.
Okay.
Tomorrow, it will not take much time, my lord. I assure you, lord.
Tomorrow at 2 p.m. we will try.
Yes, yes, yes. At 2 p.m., no problem.
Okay.
I'm deeply obliged.
Lord, with due consent, I beg to mention item number 31.
31.
I've taken the consent of the applicant. Lordship, may kindly admit it.
31.
Yes.
Okay. On the pair being made by Mr. Bhatra, learned counsel with consent from the other side, the matter stands adjourned to be listed after 2 weeks.
If you.
Lordship, this part-header matter may be listed. Part-head matter, Lordship.
Which matter?
Part-head matter, my lord, it is not listed. Let it be listed any day this week, my lord.
When do we want?
For listing, my lord, part-head.
When?
On Thursday, my lord. For admission, my lord.
On 30/30.
Obliged. I'd like to mention two matters pertaining to the state petitioner in the family court, your lordship. Your lordship, in one matter, your lordship, this court is monitoring the case that is going on in the family court, your lordship. The next date is on 1st of August, your lordship. So your lordship may take it on any date this week. Your lordship.
Take a date from him.
28.
My lord, I beg to mention IA, my lord, limitation petition, my lord. In RSA, my lord, 17 days delay was there. And already we have served the notice to Dusty to the respondent, my lord. Proceed may kindly take up this matter on Friday if possible, my lord.
Okay. Yes. When? Tomorrow hearing that. Day after tomorrow.
23rd.
Yes.
My lord, IA Civil 815/2025 fixed today but not listed. Let the matter be listed on Wednesday.
On
Wednesday,
Wednesday. Okay.
deeply obliged.
It's listing for a petition for withdrawal. CRPI.
When?
Any date.
24th.
May I please, your lordship? Lordship, I beg to mention for listing or
When?
motion, lordship. Lordship.
When?
Day after tomorrow, lordship.
25th. 25th.
Obliged.
Your Lordship, I beg to mention item number 23. Maybe. When do we want? It takes after 2 weeks. After? After 2 weeks. The objections are ready, but the respondent is. You for? I'm for the respondent. Appear being made by Mr. Mr. NN Upadhyay, my sleep. NN Upadhyay. Learned counsel, appearing on behalf of Mr. On behalf of Mr. NN Upadhyay, I'm A.K. Sharma. Item number 28.
23.
Item 23.
Look, there is an interim also in this case. In this case, there's an interim granted.
You are for?
Interim,
You are for?
I am for the appellant petitioner.
Okay, seconded by learned advocates of both the parties, recessal is the matter. When? After 2 weeks. After 2 weeks. Okay, interim order first earlier shall continue. Yes.
Please, your lordship, with the consent of the another party, opposite party, I beg to mention item number 22, lordship. To kindly pass over for the day due to eye operation of my senior.
On the pair being made by Miss
Bhi Haklari.
V. Cutler, a learned counsel for the appellant with consent from the other side. The matter is then adjourned to be listed after.
Lordship on 31 July.
31st, on 1st August,
No,
First of all,
after 1st August.
on 4th August.
May I please, sir? So
Yes.
with the consent of opposite party, I beg to mention item number 27, Lord. Matter may be adjourned for 2 weeks, Lord. Sir.
Mr. Early, learned counsel for the petitioner with consent from the other side, first of all, listening the matter after 2 weeks. There,
Matter may be list motion column, Lord. Sir. Wrongly listed in order column. Opposite party is also here.
Mr. Ali submits that the matter has wrongly been listed in the order column, but it ought to have been listed in the admission column. Recessal do the needful in this regard.
Hello.
Yes,
Item number 6, my lord, it has been mentioned as F2. With the impression that, my lord, the court will resume at 10:30. So when lordship will take up, because now I have some motion with that. After that, F3 or 2.
Okay.
Admission hearing, ma'am.
when?
Today, still I am not seeking an adjournment, but lordship will accommodate it, my lord, if it comes immediately.
After some time then,
Yes,
we'll take up the motion matter. first.
yes, ma'am. Yes. Obliged.
I beg to mention item number 36 also.
Item number
36.
yes.
It may be passed over the day. Lordship. In this case, I have filed,
You are for
I'm for the appellant, Lordship.
Mr. K.K. Bhatt, learned counsel for the appellant with consent from the other side, press for list on a press for adjournment of the matter for the day. Fair allowed. The matter is then adjourned for the day.
All right.
Your lordship, I'd like to mention 2 cases for listing, your lordship, one MFA and one IA civil, your lordship.
When?
During the month of August, first week of August,
On 6th August,
oblige your lordship.
I'd like to mention for listing is IO, CRP IO, my lord. So it's fixed on April, but it's not listed. So it may be,
When do you want?
my lord,
When do you want?
next week.
Next week. Take it.
30
Yes,
July.
Mr. Sen.
My lord, I have a small prayer, my lord.
Hmm.
Item number 12, this list, my lord. My lord, I doubt whether it will be taken up or not, my lord, because paucity of time.
Item number 12.
12. My lord, the problem here is, my lord, the execution case has been started. Now, my lord, they are all about to, my lord, demolish my my dwelling houses,
Will you hear you?
my lord,
Will hear.
My
We'll
lord,
take it up today.
my lord.
Items for motion, item number 1.
Well, I seek your lordship's permission to withdraw this application. Madam.
Pardon?
I seek your lordship's permission to withdraw this application. Madam.
Withdraw.
Withdraw.
Mr.
sir.
T.P. Solia, learned senior counsel, assisted by Mr.
UP chale, hello.
Learned counsel for the petitioner submits that he has an instruction to withdraw this petition. where is accordingly allowed, there's a civil revision petition stands disposed of on withdrawal.
Right.
Liberty will be required?
Liberty may not be required, my lord. Cause of action will be different.
Okay.
Item number 2,
You can apply for.
May I please answer? Lordship, petitioners before your lordship are the judgment debtor.
Yes. Okay.
They preferred a petition before the executive court
Okay.
that was rejected by the impeachment order that is under challenge in this revision petition. Lordship, kindly have a look at the finding of the learned court below. Lordship, kindly come to page 108.
Finding at paragraph number
Lordship, it is paragraph number 42,
40.
42, 42.
Yes.
May I read it? Now by order dated,
Mr. Mozumdar,
Lordship,
you see, the decree has already been executed.
Lordship,
The suit land has already been handed over to the decree holder,
Lordship,
and though there was a discrepancy in the patta number in the schedule A and B,
Lordship,
yet two Latmandal went there and they have identified the land.
that is true, Lordship.
Then-
One thing, Lordship, earlier they made a prayer for amendment that was rejected. That order was not challenged before any forum. One thing, Lordship, and other thing, plaintiff vendor denied any sale.
Pardon?
Plaintiff vendor denied any sale to the plaintiff vendor, Lordship. He purchased from pro forma dependent number 1 according to the plaintiff, and pro forma dependent number 1 purchased the land from pro forma dependent number 2 who denied the sale. Under such circumstances, there is a defective patta number, Lordship, and the prayer for amendment was rejected. Whether under such circumstances, sale was denied. Lordship, kindly, I have annexed the evidence of the
Because petition for amendment of the schedule was rejected.
Lordship.
Uh,
Was not challenged also.
no, maybe whether that would have any consequence upon this present petition.
Lordship, it is nowhere tell you the Lordship land which was occupied by the present petitioner. It was totally denied by the wife of the pro forma dependent number 2, Lordship. I have annexed her Lordship evidence, Lordship, before the trial court. Lordship, kindly have a look at page 110, Lordship.
Yes.
Merit, Lordship. That I know both plaintiff and the defendant of the above noted case, that I know pro forma dependent number 2, Abul Qasim, as my husband. He never sold his land from that number 1098951, measuring 7 biga to Alimuddin. Alimuddin, who is the vendor of the plaintiff, Lordship, that the defendant has been cultivated over the land measuring 7 biga, dag number such and such, Miadi patta number such and such, in the year since 25 years, and in the initial 5 years, they were our Adihar, but about 20 years, they purchased the said land from my husband. It is known to me.
Sir, are we supposed to appreciate the evidence in civil revision petition?
Lordship,
Are we supposed to appreciate the evidence in civil revision petition?
Lordship, that is also Lordship. Otherwise, Lordship, here is a case, Lordship. It is their assertion in the
This is
deed
not the
also,
second
Lordship. Correction deed also, it is dag number 346. Correction deed also dag number 346. Where and
Proforma dependent number 2 also denied any say. They purchased land from dag number 346, not from 350 or any other dag. From that dag, it is new dag number 175 emerged, Your Lordship. They had also impression they did not prefer any appeal, Lordship. It was their impression that it is not telling dag and patta with their land. That's why even they did not cross-examine the plaintiff witness also, Lordship.
Then
Present Lordship petitioner, that is defendant, they had impression they in their WS categorically stated that land from dag number 175 was not sold by the, and it is also corroborated by the plaintiff's vendor's vendor.
So as I have already stated, the land was identifiable and Latmondal identified the same and the decree was already executed. There is no merit in this petition, we dismiss it.
Three,
Obliged.
Lordship issue that limitation issue, Lordship. That regarding limitation issue, Lordship had on the last date had sought for further instruction. One document I had given, Lordship, that one.
No, this is a decision of which court?
That is, Lordship, I have sought instruction from my client, but till today I have not received any instruction.
After 1 week. On the pair being made by Mr. Soikia, learned counsel for the petitioner, SSL is the matter after 1 week.
item number 4.
Your Lordship. My Lord, Your Lordship order dated 16/7/2025. Your Lordship was granted liberty to produce the order by which landed principal judge has was called for, my Lord, by the landed principal judge. So I filed an additional affidavit, my Lord.
When?
Today, my Lord.
Today?
Yes, my
That's
Lord.
not place on record.
Lordship may kindly peruse. And there is the order, my Lord.
Place the matter on Wednesday, along with the affidavit filed by filed by the petitioner.
Yes, my Lord.
Filed by the petitioner. Till then, interim order pass earlier shall continue.
Lordship.
Item 6, fixed at 2 p.m., parted matter.
Mr. Bhuya is on Lex in court 1.
Pardon?
Mr. Bhuya is on Lex in court number 1. So after some time,
When? Today?
yes, Lordship, after some.
Item 5, parted matter.
May please, Your Lordship. Lordship, kindly take up the matter day after tomorrow, Lordship.
Why?
My senior TJ Monte, he will argue, Lordship. He is on legs in some other court, Lordship. This is parted matter.
On the pair being made by Ms. P. Bhattacharya, learned counsel for the petitioner, SSL is the matter day after tomorrow.
Obliged.
Item 7 and 8.
My lord, in this case, the suit premises has been acquired by the government of Assam. So the government of Assam now has become the owner in view of the notice. So in view of the provision of section 6, rule 2, your lordship, where a notice as aforesaid is published in the official gazette, the requisition land and premises shall on and from the beginning of the day on which the notice is so published vest absolutely in the state of government. So it has become absolute property of the state government. So state government is necessary party. It cannot proceed without the presence of the state government, my lord.
Who is for the respondent?
And I have to take further instruction from my client. What is
Will
the,
you furnish a copy to him
yes, yes.
of this letter?
Yes.
Minor disputes relate to landlord tenancy matter. So I don't think so. There is any active role of the government. It's a dispute between landlord and tenant.
Landlord has become the state of government. By the operation of law, the state government has become the owner, landlord. He is no more landlord in view of the provisions of the Land Acquisition Act. So this is the law point involved.
Yeah.
My lord, the suit was for ejectment of tenant, my lord, who are the now revision petitioner. And there has been concurrent finding by the trial court as well as the lower appellate court in our favor, my lord. Only on one point that we have filed a second CRP, my lord, is that the appellate court, there was a compensation granted. It has reduced the compensation without recording any reason. My lordship is aware, my lord, Honorable Apex Court, where Katrina of decision has held that if a judicial pronouncement is without any reason, then it becomes arbitrary. And that I will establish, my lord, on the records as well as judgment. Insofar as their revision is concerned, my lord, I recently, my lord, not recently, 2014, my lord, Constitution Bench of the Honorable Apex Court has examined the powers conferred under Section 227 and 115 revisional powers of the High Court in rent control matters, and have come to a finding, have actually laid down the law that re-examination and re-evaluation of evidences under revisional powers is not permissible.
No, that is well settled.
And this has been followed, my lord. So, my lord, in this case, I think.
No, today he has taken another stand that the land has already been acquired by the government.
My lord,
You
they
are
have
no
notice
longer
of
the-
issued. Yes,
you
my
are no
lord,
longer the-
insofar as the area rent is concerned, my lord, then the judgment has to stand to that extent, my lord. Land is acquired by the government will acquire it. That's a different issue. But all the while they have been defaulter in payment of monthly rent. What about this, my lord? They want to escape by taking this technique, my lord. They want to escape without paying any rent, my lord, and want to unnecessarily linger these proceedings. Since 2008, my lord, they have been in default. Today is 2025, my lord.
2018.
2008, my lord.
No, my lord, this is
They have been in default.
wrong statement. We are paying the rent.
And my lord,
And I will establish,
they
my
have
lord.
taken a
Let's sit down.
They have taken a plea I have gone through the revision application. In the revision application, there is a ground that the trial court ought to have called for the NJ records. But my lord, again, there are our high court pronouncements that burden of proof lies on them, not on us, the tenant, to prove that he has deposited the due rent in court or elsewhere. So the court's finding of defaulter cannot be said to be wrong in any sense, my lord, by both the trial court as well as the lower appellate court, my lord. So if he starts on the merit, my lord, then, but this point, my lord, that now state has to be made a party, it's an afterthought, my lord. That's a definitely afterthought. I have also got instructions from my client. Some notice have been issued, my lord, that has not attained finality now. But if that plea is allowed, tomorrow they will escape without paying my lord, that whatever default they are in, my lord. Rightly or wrongly, there are orders from both the courts below to pay the area rent, including compensation. And state is not yet. It is a tenancy matter under the provisions of Urban Area Rent Control Act. And my lord, there are repeated pronouncement that here the arena is circumscribed, my lord. In many, I think I don't have, I didn't know this plea will be taken. In some cases, my lord, this dispute on the ownership of the land, which they now try to create that state is coming. This is not available for the, my lord, court under the rent provisions of Rent Control Act. It is circumscribed. Whether they are defaulter, whether there is bona fide requirement, it's a landlord-tenant relationship, strictly, my lord. I respectfully beg your lordship to, at least this proceedings has to be confined within these parameters, my lord.
Yes. Yes, so what instruction you want to obtain from your client?
My lord, my instruction is that the notification has already been.
Just before a few minutes, you have submitted that you were supposed to obtain instruction.
Yes, because in gazette notification may be there, my lord. this notice has been issued to the landlords,
Hmm.
whereby under section, under Assam Land Acquisition Act. Now, from the date of issue of this notice, my lord, the property absolutely vest in the government, my lord.
Hmm.
So now government of Assam is the party. Government of Assam is the landlord now, by the operation of law. We cannot ignore the law. And there is a saving clause, my lord, also. This proceeding regarding this Assam Land Acquisition Act. Now, here, my lord, there is a provision for saving, that it says, my lord, no suit, prosecution, or other legal proceeding shall lie against any person for anything in which is in good faith done or intended to be done in pursuance of this act or any other made thereunder. Save as otherwise expressly provided in this act, no suit or other legal proceeding shall lie against the state government for any damage caused or likely to be caused by anything in good faith done.
Okay, that's all right. The land
Yes.
is now acquired by the government.
Government. So government is a necessary party. I have to implement the government.
No, that is a subsequent event. But are you not supposed to pay the rent for the earlier?
Now,
earlier,
your lordship,
earlier
on the
years?
merit, your lordship may kindly see. During the COVID period, the ex parte judgment and decree was passed. Now, your lordship may kindly see the record. The judicial power cannot be delegated. Here, the court master has fixed the date for cross-examination and for hearing.
Court master has?
Fixed the date for cross-examination.
Is there any
Yes.
signature of the presiding officer?
No, there is an order, my lord, 4/1/2020. During the COVID period, PO is on leave transfer, fixed 6/2/2020 for cross. How the court master can fix such that I can fix the date for cross?
That is that kind of order can be passed by the bench system. By order, under order.
Under order, this is not under. This order I have noted down, my
Okay,
lord.
let us do one thing. You obtain inspection in the meantime. We will hear the matter on Thursday.
Yes, yes, Nil.
Third, Mr. Your good name, please.
R. Hussain.
R. Hussain, learned counsel for the petitioner, and Mr.
Hello, I am G. Rahul, my lord.
G. Rahul, learned counsel for the respondent.
My lord, his submission may be recorded that the government is not necessary party.
Pardon?
He has submitted, my lord, the government is not necessary party for the purpose of this.
Yes, we
I
will
learned
hear
that
you
for
on
other,
that
yes.
one.
I submitted, my lord, the government is necessary party now by operation of law.
On that day,
He's-
we will hear you.
Yes.
Lordship is fixing the matter on which date, my lord?
Thursday, hearing day.
24th, my lord.
Yes.
I apologize, my lord. I will be Kohima bench. There is a matter, my lord. Can it be on, my lord, 29th then?
29th.
29th.
Okay,
Tuesday.
all right. 29th. Races and leaves this two petition as parted. Next.
Number 9.
Obliged.
Wait, your lordship. This revision petition against the Milord or judgmental decree passed under section 6 of specific relief act, Milord. But although this case has been listed for admission, but all the respondents were not served, Milord.
Who are the respondents upon which notices are yet to be served?
My lord. Two, 4, 5.
245.
My lord.
You are for respondent number?
I am for the respondent number 1, who is the sole respondent in the proceeding, and the remaining things are the performer respondent in the proceeding.
suit has been filed by them. They have made those them parties, my lord. And that is why they are in the party in this revision.
Mr. Sahu, learned counsel for the petitioner, and Mr.
D. Sharma, Lordship.
Learned counsel appearing for respondent number 1.
Respondent number 1.
Respondent number 1. Mr. Sahu, learned counsel for the petitioner submits that though the case has been listed today for admission, yet notice upon respondent number 2, 4, and 5 are yet to be served.
2, 4.
In that way of the matter, it is provided that Mr. Sahu shall take necessary step upon the aforementioned respondent by registered post with AD and also by usual process within a week from today. And what about 6?
Six is also made. 6 is also.
6 is.
কোনটো আছিলে বাকি কিটা মই লৈ লওঁ Lordship, Meaningful organization.
Office note reflects that their family members received the notice in respect of respondent number 2, 4, and 5. Not 2, but 4 and 5.
Yes, sir, Paul, Lordship, so far the respondent number.
In respect of respondent number 2 only. By registered post with AD and also by usual process within a week from today. Let's list the matter for. No, let's list the matter after 4 weeks. After 4 weeks.
Item number 10, interim order pass earlier.
Interim order, if pending, pass earlier, shall come.
Public.
May I please your Lordship? This revision is filed against the judgment order dated 22/11/2024 passed by the learned district judge Johar Lordship under section 24 of Hindu Mason. Page number 14 Lordship. 14 of 2015 Ms. case law under section 24 Hindu Mason Lordship. Page number 14 Lordship. Order passed by the learned district judge Lordship Johar. Those are having a government job of the sole respondent, wife of the deceased, who is filed a divorce petition before the decision, Lordship, learned decision Johar. The next one, page number 14, Lordship.
What about the respondents?
Yes, one should respond already service completed, Lordship, but not appeared, Lordship. Justice service and usual process. Affidavit filed, Lordship, regarding justice service, Lordship.
When?
5/6/2025, Lordship. Page number 94.
What is the grievance?
Grievance is interim maintenance, Lordship, 8,000 per month to the sole respondent and 30,000 pendant debt, which is barred by under section 24 of the Hindu message, because the respondent is a government service, same rank, Assam Police Department, Lordship, and suppress the facts by the affidavit, page number 97, Lordship. 71, Lordship, affidavit filed by the sole respondent, Lordship.
71.
71. Paragraph number F, Lordship. Name of employer not mentioned, Lordship. Designation not, monthly income not, details of income of the deponent, Lordship.
Do you have any proof that she is also government servant?
Lordship, this reflected by the judgment order dated 22/11/2024, page number,
22?
Lordship.
22?
22/11/2024,
Page
page
number?
number 18, passed by the learned decision Jorhat, Lordship. Assam Police Department working as a constable, Lordship. Page number, paragraph number 3, Lordship. Earning monthly salary 56,000. This is paragraph number 4 inflected by the Lordship learned decisions. In her income affidavit of petitioner against column number F, CL number 3 has indicated that she does not have any income nor any employment.
Where is that petition?
Lordship, 18, page number 18, paragraph number 4. This was affected by the learned decision, Lordship.
So in spite of mentioning said fact in the judgment, why it was not taken into consideration in the
Lordship,
judgment?
therefore, the revision petition is filed before this court, Lordship. Lordship, directed by this honorable court to bring on record 12,000 already paid monthly maintenance to my daughters, Lordship, two daughters, 6 piece. It is reflected, Lordship, 101, page number 104, annexure 12, Lordship. This was passed by under section 125 of the CRPC, Lordship. Already being paid to my daughter. Two daughters, Lordship. Vernacular is page number 105, Lordship. And the divorce petition filed by the respondent, Lordship. Many cases filed against me, but
Both the parties are of same rank.
The same rank, Lordship, Assam Police. One complaint was also passed.
One?
And a complaint case was passed, filed against me, Lordship, 498A and 494. That was disposed and acquitted me. Marriage was, Lordship, 2003 and separation 2015, Lordship. Divorce petition is pending, Lordship.
Any other point?
This is the point, Lordship. Suppress the fact and affidavit file, which was Rajesh and Neha Singh, all Neha clearly stated that conduct of the party seeking relief is very much necessary, Lordship. Section 24 of maintenance pendant
That
right,
affidavit is that page number?
Lordship.
That affidavit is that page number?
Page number 71, Lordship,
71.
11 part. Annexure 10, page number 69. 11 point is 71.
So already there is an order for payment of maintenance by the magistrate.
Mr. Lordship, already paying, Lordship. I have no objection because I have a two-child, Lordship.
You are paying 12,000
12,000,
per
6,000 each per month, Lordship,
for both the children.
on both the children, Lordship. First was 9,000. After that, 127 CRPC, Lordship, it enhanced to 12,000. I was again paying regularly, Lordship. But given in section 24, Lordship, pendant and
Apart from the observation made by the learned district judge, do
Lordship.
you have any other document to show that the respondent herein is working as
admitted, Lordship.
less
So,
than?
admitted, Lordship.
No. Do you have any other document?
I have not
like
filed.
a salary slip
I have not
or
filed it.
any appointment letter or any identity card?
Nice, no, not filed. Because Lordship, that will be not hand over to, not give me for filing this. because receipt of notice, so that will not
Okay,
create.
you can obtain this salary certificate
Can be
from the
lordship,
department.
can be lordship. Maybe I'll fix and date or
Then on what basis the learned district judge has observed that she has been working as land snire?
admitted lordship.
Where?
This is. Affidavit of high question है ना. Page number 22 lordship. Page number 22 annexure 2 that was a file by the petitioner presently residing at maze between the petitioner. Both the parties started conjugal life lordship. Page number 22.
Yes.
Hmm.
Where it is admitted?
Petitioner যে কোর্ট আসলে না সাজেশন তাই সাকরি করে নিজে কইছিল না এটা আসলে সাজেশন কিমান পেজ নম্বর কোন আছে কিমান 32 32 পেজ নম্বর 32 paragraph number
Paragraph number?
paragraph number paragraph 2 percent paragraph 1 জানা পড়িব লাগে না জানো क्या नंबर देखते हैं एडमिट क्वेश्चन है वन पेज
Where it is admitted?
Lordship, page number 46, paragraph number 14. Doing her cross examination stated there. May I read, Lordship? Page number 46, paragraph number 14. May I read, Lordship? In her cross examination, PW1 stated that PW1, that means respondent, sole respondent, that her two minor data are getting maintained from the second party as per order dated passed in Ms. case number 442016. She admitted that her two data are getting maintained regularly. She stated only her mother is residing in Pendle House. She admitted that she constructed house at Baksung and she had two daughters residing at house past last 2 years. Her mother too state there something. She stated that she looks after 3 years land so and so. That her father passes so and so and two personal loans having housing loan and EMI. She denies that she has neither mentioned in her complaint petition nor her evidence that she is a police constable. Denied it, Lordship. She gets salary rupees 52,000 per month. She admitted the second party working as a police. He is in same rank. Same rank. That is sole respondent. And that gets salary 52,000. Admitted that they filed a divorce petition 35/2022.
No, she denied the suggestion.
Denied the suggestion.
Then better you do one thing, you produce the salary certificate of the opposite party.
Lordship.
Respondent. Partner side.
Here, Lordship.
Learned counsel for the It is. Mr. Bora submits that he will bring on record the salary certificate of the respondent opposite party hearing by way of by filing an additional affidavit.
Lordship.
And press for granting him some time, there is allowed a the matter on as part heard.
Interim maybe let's continue. There is interim.
First protest. First protest.
Lordship,
Interim order personally shall continue.
highly pleasure.
Item number 33 by VC Mode.
May it please, my lord.
Yes.
My lords, this is an appeal against the orders dated 4th of March 2024 and 6th of April 2024 passed by the reference court. Our case, my lords, was relating to non-appearance. My lords, we were not served before the reference court. So that was our case, and there was some delay also. So by an order of 14th of May 2025, my lord, this honorable court has already condoned the delay and directed us to file the ad valorem, my lords, the court fee, which we have already paid. And subsequently, the matter came up, my lords, on the 18th of July 2025, when, my lords, we were directed to file this application for stay, which we have done, and we've already served a copy of the appeal, though, of course, our case was that we had already served them, but nevertheless, we have served them again. So that has been complied with, my lord. So I would like to place my case regarding the appeal, because what has happened, my lord, is that in the execution, despite pointing out that the matter is pending before this court, there has been an order on the 14th of May condoning the delay and setting the appeal down for hearing. The trial court, my lords, I have placed that particular order in my application for stay. It has proceeded with the matter, my lords, and also today I am told, my lords, my instructions are that they have the decree holder has filed an application under order 21, rule 41, calling for the authorized representative of the judgment debtor, which is us, my lord, to disclose the assets and other things which my lord already knows. So I would like to place.
Mr. Sharma, you are pressing the IA today?
My lords, I am pressing the IA, but I would have to satisfy my lords on the main point that we were not, my lords, a party in the proceedings before the reference court. We were not served and we had no notice of the proceedings. And my lords, it has been passed behind our backs. And the only time that we got knowledge was when the government of Assam sent a letter to us pointing out that this particular order has been passed, the judgment has been passed, my lord. So I have placed all the orders of the reference court, my lords, for my lord's consideration. Because if my lord sees the order also of the 14th of May 2025 of my lord's predecessor, there also, my lords, this has been taken note of.
Who is for the opposite party?
Lordship, I am for the opposite parties. Respondent number 4 to 30, Lordship.
Respondent number
4 to 30.
4 to 30.
Yes, Lordship.
So have you received this copy of stay application?
Yes, Lordship. We have received the copy of the stay petition, Lordship. But Lordship, at this point of time, Lordship, stay cannot be granted, Lordship, as the applicant is required to pay the some portion of the decretal amount, Lordship, as per the provisions of Order 41, Rule 1 of Sub-Rule 3 of CPC, Lordship. As Lordship, that and Lordship, also the Order 41, Rule 5 of Sub-Rule 5, Lordship. If Lordship appellant is failed to deposit that decretal amount, Lordship, then stay cannot be granted, Lordship. Stay cannot be considered. So, Lordship, first of all, the appellant is required to pay some portion of the decretal amount awarded by the trial court. Lordship, more preferably the 50% of decretal amount. As Lordship, it is a common practice followed by the Guwahati High Court and other high courts of India, Lordship.
Okay, Professor, let Mr. Sharma complete. Yes, Mr. Sharma.
Just to give a short brief counter to my learned friend, but the point that my learned friend points out, I will, my lords, my endeavor before the court will be to demonstrate that we were not served at all and we were not parties before the proceedings. Hence, the issue of pre-deposit or any kind of deposit as a precondition to the admission of the appeal, my lords, I would try to my lord, demonstrate to my lords it is not warranted. So for that, my lords will kindly see that the petition which was filed before, my lords, a reference court, the application, That, my lords, will kindly see at annexure 11, page 130,
Annexure
134
11 of main petition.
of the main appeal paperbook, my lord.
Okay.
Page 134, my lord. This is an application which was filed by the additional deputy collector before the reference court, my lord, for implement of power grid. Because, my lords, in the reference case, we were not made a party. My lord has page 134.
Yes.
My lords will kindly see the cause title. It says, my lords, so-and-so versus the deputy commissioner, and it says, my lords, an application by the additional deputy collector praying to implead Power Grid Corporation, that is us, as a necessary party to the suit. Now, what happens, my lord, is that this particular application is numbered as application 265, which my lords will find at page 148, which are the orders of the reference court. My lords will kindly directly come to page 148. From 147 onwards are the orders of the reference court, the certified copy. Page 140, my lords will come to page 148.
Because Sharma, your submission is not audible properly.
I am sorry, my lords. Am I audible now, my lords?
Yes.
Yes.
To some extent.
I'm so sorry, my lords. I think there may be a connectivity issue, my lord. My lords, I'll try to be a little louder, my lords. I will try to do that. So, my lords will kindly see page 148. My lords, the order sheets start from page 147. 148 is the order.
Yes.
Of 16th of February 2023, which is the date on which, my lords, the implement application was filed, which I have pointed out to my lords. Now, my lords will kindly see that this particular application, 265 of 2023, praying for impediment, is numbered as 265, which is evident from, my lords, this order dated 16th of February 2023. Now, proceeding further, my lords, will kindly come to page 149.
Yes.
This is 3rd of May 2023, my lord. And
yes.
The order says that objection against 265 has been filed. And the matter is then, my lords, fixed for hearing. My lords will see for hearing on 1937 of 2023 and 265. My lords, the date has been fixed. Then, my lords will kindly see 3rd of June on the same page, 3rd of June 2023. And this is, again, my lords, 265 is fixed for hearing on 28th of June 2023 at the bottom of the page. My lords will kindly see that. My lord has that?
Yes.
At the bottom of page 149, it is fixed for hearing on the 28th of June 2023. 265 is also mentioned. Now, kindly come to, my lords, the very next page on the top of the page. This is an order of 28th of June 2023. Some new application is filed for adjournment. There is no reference to 265. Even though the matter is fixed on the previous date for 20th of June 2023 for hearing of these IAs, including my IA 265 of 2023, the order dated 28th of June 2023 only shows that there is an application numbered so-and-so filed for adjournment. So the matter is then adjourned, my lords, to 31st of August 2023. My lord has that on the same page. Now, my lords will kindly see order dated 31st of August 2023. It says that fixed for 11th of December 2023 for hearing. My lord sees that on the last line of that page, my lord, at page 150, my lord has that. 11th of December 2023.
Yes.
Now, my lords, comes to page 151, which is the order dated 11th of December 2023. So there has been a transfer, my lord, so the matter is adjourned. And then my lords will kindly see it is fixed for 4th of January 2024 for hearing. And please also bear in mind while reading these orders, there is no reference to IA number 265 of 2023, which is the application for impleadment. So it has not been considered till now. Now, my lords will kindly see on the next page, page 152, the order dated 4th of January 2024. It says heard both sides.
Yes.
My lord has page 152. At page 152, the order is of 4th of January 2024. It says today it's taken up for final hearing. Heard both sides, fixing on 3rd of February 2024 for orders. So my respectful submission is, and this is evident from the order sheets, that this application 265, which was for impleadment, for my impleadment, which was filed by the collector, that was never considered and no order has been passed, my lords. Otherwise, as my lords are aware of the procedure, if that application had been allowed, then there would have been a specific order to that effect saying that IA number 265 of 2023 is allowed. So and so, my lords, is directed to appear. Notice is issued to me. So there is no such order from the records, my lords, which shows two things. One is that this application 265 was ever decided, or that notice was issued to me pursuant to the consideration and pursuant to notice being issued to me. That is not reflecting, because the first effective order, my lords, is 4th of January 2024, which is at page 152, where it only says that it is taken up for final hearing. So the consideration of 265, application 265 of 2023, there is no reference in any of these orders. And my lord, these are orders, these are certified copy of the orders. So this is proceeding in sequence. It is in the, my lord's, handwriting of the judge. So my lords, nobody can dispute that also, my lord. So this is actually my case is, my lord, that even though there is an application filed by the collector, and rightly so, because my lords, I am the requisitioning authority. It is the acquisition was done at my my lord's request by the state of Assam. So I am a party interested. I am a person who's interested because I will be paying the compensation. So rightly, the collector files this application because I was not represented. Hence, my lords, this application 265 was filed before the court. But this particular application is not decided, no notice issued to me, and then the matter is taken up on the 4th of January 2024 for final hearing without me being present, my lord. So, and my lords will kindly go for further, my lords, just to show my lords how the sequence
Now,
of
after filing of the petition number 265 of 2023, whether you have pressed the matter before the learned reference court?
No, my lords, I was that particular application was not filed by me. It was filed by the state. It was filed by the collector on my to implead me. To implead me. My lords will kindly see that application. My lords kindly goes back to that application.
Page number?
My lords, that application is at page 134, my lord.
134.
It is filed by the collector, not me. I am not even a party before that, my lord. Kindly see page 134, my lord. I'll take my lords back.
Okay.
Please see page 134 and please see what it says, my lords, in the matter of application by additional deputy collector praying to implead the Power Grid Corporation, which is me, as a necessary party to the suit. So this application was filed by the collector, and rightly so, because I, my lords, will see the cause title. I was not made a party. And this is where the fraud comes in, my lord. Because ideally speaking, my lords, the authority who is to pay compensation is required to be represented before the court, because that is the main party which is interested. And I have judgments to make good my case that in a land acquisition case, my lord, the authority which actually pays the compensation is the party interested. Hence, this application was filed by the collector. And then I have shown to my lords the orders of the reference court, where, my lords, that application number 265 of 2023, which the state had filed, the government, the revenue department had filed, was not taken into consideration, was not decided by the reference court, no notice is issued to me, and then the matter is heard for finally on the 4th of January 2024, my lord. As I've shown to my lords, the order of 4th of January at page 152, the matter is heard finally. but without considering that application. And then, my lords, what happens is the final judgment is passed on the 4th of March 2024 at page 153, my lords will kindly see. Fourth of March is the first order. That is at page 153, my lord.
Yes, you have shown this order.
Yes, I had shown the previous order, but this is the order by which, my lords, the order disposing of the LA case, my lords, that is the order disposing of the LA case on the 4th of March 2024. Then there were certain corrections which were carried out, my lords. The next order at page 154, just to complete the narration of how the case moved before the reference court, my lord. Page 154, there were some corrections which were carried out. 6th of April 2024. So therefore, we have challenged both the my lords, both the orders, both
Yes.
of the original order of 4th of March as well as, my lord, 6th of April.
Now, what is your prayer?
My lords, my prayer is that this matter needs to be remanded back, my lords, to the reference court. I may be heard, and then, my lords, an effective order can be passed after hearing me. That is my case, because I have till now, my lords, not been heard by the reference court. This order was passed behind my back, and in fact, my lords, I have the knowledge which I attribute to how I got to know about this order is at page 17 of the delay application which I had filed. It is for the first time when the deputy commissioner, my lords, writes to the general manager of Power Grid. My lords will kindly see that application. This is IA number 3029 of 24.
IA number
3029 of 24.
Yes.
That is the application for condonation of delay, my lord. And, my lords, the first annexure at page 17 is letter from the district commissioner, my lords, to the chief general manager of Power Grid. So we say that on this date, for the first time, we get to know that these people have moved the reference court and that this judgment has come. And my lord's predecessor has taken note of all this and condoned the delay, because my lords, had demonstrated to my lords that the date of knowledge should be attributed from here, and then subsequently, my lords, the delay has been condoned. So my respectful submission, my lord, is that in view of the fact that I was not represented before the reference court and I was not heard before passing the judgment in the reference court, my lords, I may be either my lord sets this appeal down for hearing, or my lords will consider, depending on how my lords would like to fix this, depending on my lords what my learned friend from the other side has to say. There are two ways to do this, my lords, will then hear the matter. But I would, my lords, if my lords are today giving them an option to file a reply, then I would request that at least for the time being, my lords, the execution proceedings may be stayed, because, my lords, now my lords will kindly see with the stay application I filed an order. Please see how the executing court is proceeding, my lord. The new IA for stay which we have filed, my lord. And the first annexure in that application, page 18.
Okay.
Page 18.
Okay.
This is an order of 20th of
What
June.
is your submission whether PG's Power Grid Corporation is a necessary party in the land acquisition?
Lordship, the learned senior counsel Lordship, he is out of station Lordship, and he will argue upon the merit of the appeal Lordship. But Lordship, for today, we have no objection in admission of the appeal Lordship, but in condition to 50% deposition of the decretal amount Lordship. And Lordship, at this point, Lordship,
If we are going to set aside the impugned order, then
Lordship, that can be possible only after the admission of the appeal Lordship.
yes.
But Lordship, appeal, Lordship, Order 41, Rule 1 of and Sub-Rule 3, Lordship of CPC. Order 41, Rule 1, Sub-Rule 3.
That is there, but here one of the parties has not been heard by the learned trial court, one of, by the reference court.
But Lordship,
Whether Power Grid Corporation is a person interested in the
yes, Lordship.
acquisition proceeding?
Yes, Lordship, they are
Yes.
Lordship. But
Then Who
Lordship,
will pay the amount, compensation amount? Power Grid Corporation?
no, Lordship.
Oh,
It will paid by the
state,
DC, Lordship.
state.
Yes.
No, no.
Lordship, actually, Lordship, my senior will come and argue upon the merit, Lordship. But today, as he is not in town, Lordship, he's actually went for the execution matter in Biswanath Hareli, Lordship, for the same matter, Lordship.
So then let it be on Thursday,
Yes, Lordship.
Mr. Sharma. Let our senior come. We'll finally hear the matter. You are not audible, Mr. Sharma. You are not audible.
I'm so sorry. I kept it myself on mute, my lords, because my learned friend was arguing. My lords, I was submitting that this particular, my lords, the execution petition has been fixed on the 28th of July.
Yes.
So
No,
if my lords are fixing it on
we'll
Thursday,
hear
my
the
lords,
matter on Thursday.
Thursday, my lords, Thursday is fine.
Thursday.
Thursday.
Lordship, kindly give me a date of 1st August, Lordship.
No, 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 no.
The matter is,
Thursday.
my lords, now,
Thursday.
as I had submitted, my lords, now what has happened, the executing court today has, my lords, on an application filed by the decree holder now, my lords, the respondent, they have now called for the persons to appear personally. All the people from the officials from Power Grid have been called on the 28th of July, my lord. So I'm objecting to my learned friend. I would have normally not objected to a junior counsel, my lord, but if my lords could fix it on Thursday, my lords, we will argue the matter.
Yes, Thursday. You let your counsel.
But Lordship, if the as the brief is with my senior Lordship, brief of the case is with my senior Lordship. So Thursday I will be handicapped, Lordship. If I have to argue the matter, Lordship, then I will be handicapped, Lordship. As brief is with my senior. I have only the memo of appeal and the IA filed by them, Lordship, in 18th, Lordship. The IA filed on 18.
No, whether your senior will remain present on Thursday.
No, Lordship, he will come on 30th of July, Lordship. That's why, Lordship, I am praying that the matter may be fixed on 1st August.
Next date is fixed before the trial court on when, Mr. Sharma?
28th July, my lords, 28th, next Monday. My lords, this is the problem. I'm sorry to, my lords, there's a junior counsel appearing on the other end, my lords, but I must point out that, my lords, it is unfair on the part of the respondent to press the execution. And, my lords, the reason why my learned friend is coming back on the 30th is because he wants to press the matter on the 28th of July. So instead of, my lords, pressing it in execution, I have no objection, my lords, the matter may be fixed as per the convenience of my learned friend. I have no objection. But if it is fixed anytime before 28th, my lords, I will be praying for a stay of the execution, my lord.
Let him remain present through VC.
Okay, Lordship.
VC.
Lordship, I don't think as they are in Biswanath now, Lordship. I don't.
No, it is not your case that Biswanath is not connected through VC.
But
anyway, heard Mr. C.P. Sharma, learned senior counsel, assisted by Mr. Learned counsel for the appellant, and also heard Miss
J. Bezbura, Lordship.
J.
Bezbura.
Bezbura, learned counsel for the respondent. Place the matter on Thursday for further consideration. Along with the IA number 2263, 2025.
I'm deeply obliged, my lords.
Standing item 6 for admission. Order letter.
May I please, your lordship? My lord, my part is almost over.
Yes,
My
your
lord,
part is
my
over.
friend may.
Yes, Mr. Google.
My lord, I would like to refer to the various annexures first.
Probate.
Lordship will see page 30 for a moment, madam.
Yes.
Page 30 of the writ petition. This is the engagement order whereby the petitioner was engaged as initially as an honorary teacher by the managing committee pursuant to resolution adopted in 2019 in 1999. Now, Lordship, the status of the service is honorary, initial, ma'am. Now, Lordship will see page 32. It's a order dated, my lord, 8th of January 2001. Issued by the Additional Secretary to Government of Assam Education Department. My lord, by this order, the service of the petitioner was regularized. May I read the first para? With reference to the subject cited above, I am directed to forward here with an application along with its enclosures received from Muhammad so-and-so, honorary Hindi teacher of so-and-so in the district of so-and-so, regarding regularization of his service, which is self-explanatory. You are therefore requested to take necessary action for regularization of his service with that prospective effect by way of adjustment against the vacant post of Hindi teacher of Indira High School in your district immediately. Pursuant thereto, page 33 is the regularization order. Lordship will see, my lord, in pursuance of the government letter dated so-and-so, received from the secretary so-and-so, the service of so-and-so is hereby regularized by way of adjustment. Now, my lord, there is no such mode of regularization by way of adjustment. As Hindi teacher, in this scale, so-and-so, so, my lord, on 6/2/2021, he was regularized. Initially engaged in sometimes in, my lord, February 1999. Now regularized in 2021, February 2001. Thereafter, while he was continuing in service, his services, his regularization order was again cancelled. In 2003. Lordship will find that in between he approached the Honorable Court. Lordship will see one order of the Honorable Court at page 39. WPC 777 of 2002. Lordship will see page 40. It is an order whereby notice was issued. It says, also notify the parties that the prayer for interim relief shall be heard on the next adjournable date. Till such hearing, the operation of the impugned orders dated 3/9/2001 and 19/9/2001, so far as it relates to the petitioner, shall stand stayed. Now, these two orders, Lordship will find, my lord, in it's part of the petition at page 34. Page 34 is that, my lord, letter dated 3/9/21, which was under challenge before the Honorable Court in that particular writ petition of 2002. It says, I am directed to say that the government has already made an order to the effect that services of those teaching and non-teaching staff of the provincialized high school, high secondary school and high school, high madrasa has been regularized by way of adjustment against any vacant post during 2000-2001, that is after the constitution of the state level empowered committee, without this approval. You are requested to furnish the particulars of such teaching and non-teaching staff to this department on priority basis in the form of proposal through Director of Secondary Education Assam to review the matter. It is further directed that the salary bills of such teacher, non-teaching staff are not to be prepared and drawn till necessary instruction received from the government. Basically, my lord, by this order, the salary was directed to be stayed. Then in the next impugned order, letter, Lordship will find that page 36. It says, with reference to the subject cited above, I have the honor to say that the government has already made an order to the effect that the services of those teaching and non-teaching staff of your school has been regularized by way of adjustment against any vacant post during 2000-2001 after the constitution of the state level empowered committee without its approval. You are requested to furnish the particulars of such teaching and non-teaching staff of your school as per pro forma being given to this office. It is further, so my lord, salary was directed to be stayed. My lord, here I would like to, my lord, inform the honorable court that, my lord, prior to the constitution of the finance SIU department, lordship has been hearing this term, my lord, finance SIU approval is not there. Prior to that, it was a state level empower committee. Before appointment, a particular approval was required to be taken from the state level empower committee. Now, my lord, subsequently in 2005, the finance SIU came and this state level empower committee was dissolved. Now, my lord, in 2001, state level empower committee was there. Here, my lord, the adjustment or the regularization was done without the approval of the, apparently, my lord, approval of the state level empower committee. Since it was prior to 2005, July 2005. SLEC, there is a term, my lord, state level empowered committee.
That committee was prior to 2005.
Yes, July 2005, my lord, it was the state level empowered committee. After that, my lord, it is the finance SIU department whose approval was required before filling up of any post by regular recruitment.
So, do you have any other document to show that approval from the state level empowerment committee or from the finance department, finance SIU department has to be
It
taken?
is a mandatory requirement. That those notifications I
Where
can
it is
provide.
provided?
My lord, I will provide, my lord, but let me continue. I will provide it. But today I don't have it, but I will place it. But let me, my lord, place the facts, at least today. That part I will complete. Lordship will see 39, my lord, that honorable court's order. Where, my lord, these two documents were put to challenge. Lordship has already seen, my lord, here only the notice was issued. No direction was made, the notice on the interim prayer. Now, page 41, there is a speaking order now. That has been issued by the Director of Secondary Education, Assam. Lordship will see page 41, annexure 8. Here it says, my lord, peruse the honorable court's order dated 18 to 2002. There is an order where, my lord, notice was issued. Under WBC so and so, peruse the application dated so and so, received from the petitioner to provided, my lord. Perhaps, my lord, he has served a copy of that order, that notice issued order. Now, my lord, here, Lordship will see the finding now. Petitioner Sri Altaf Hussain was appointed by the managing committee of so and so school, which is an ad hoc school, my lord. It's not a provincialized school. And subsequently, his services was adjusted in the Indira High School, Gwalpara, against a vacant post of Hindi teacher. Now, Lordship, my lord, Lordship has been, my lord, taking up similar cases where, my lord, it has been the consistent stand of the government that in a provincialized school, without there being a selection, under Article 14 and 16, advertisement, interview and all, my lord, it cannot be, my lord, no post can be filled up in a provincialized school. Branchside school, my lord, it is provincialized, there is a separate issue. Moment it's a government school or a provincialized school, if a vacancy occurs, it will have to be filled up by, my lord, proper selection. But here, in the case of the present petitioner, he was adjusted. So may I proceed further? Is an ad hoc school and subsequently his service was adjusted in the Indira High School, Gwalpara, against a vacant post of Hindi teacher. As per records, the petitioner Sri so-and-so, also not selected candidate, Lordship will see, for appointment in the provincialized school. Therefore, adjustment of his service in the Indira High School was wrong and illegal. In view of the above finding, the order of adjustment of service of so-and-so is hereby cancelled. Well, that 2001 order is now cancelled. If he has any lawful ground for legally claiming the post which he is holding, he may file an appeal before the undersigned within 15 days and that will be considered as per provision of existing rules. So an option was given that if you file an appeal, if you agree by the speaking order, if you have anything to show that, that he is entitled for regularization. My lord, as per that liberty given, page 41, an appeal was preferred by the petitioner. He acceded to the order and he preferred an appeal.
Page number
43, annexure 9. That appeal was submitted before the Director Secondary Education, Assam. It was dated, my lord, 3/9/2003. And And the speaking order was 21st of August 2003. So this is the appeal. I need not go through it, my lord. My lord, the appeal was pending before the my lord authority, and it was not considered. As a result, the petitioner again approached the Honorable Court in 2003 at page 48.
Yes.
And that writ petition was disposed of on 5/1/2006. Lordship will see, my lord, the second para. Mr. So-and-so submits that since the appeal is pending before the appellate authority, it will be appropriate to issue a direction to dispose of the same. Considering the submission made by the learned counsel for the parties, I am of the considered opinion that the writ petition need not be detained here. Instead, it is provided that the Director of Secondary Education Assam shall take on record the Annexure 17 appeal dated 3/9/2003 and dispose of the same in terms of Annexure 16 order dated 21/8/2003. The appeal shall be disposed of within a period of 2 months from today. Mr. So-and-so shall make necessary communication with the Director for compliance of the order till disposal of the appeal within the stipulated period of 2 months. The service of the petitioner shall not be disturbed, if not already dispensed with pursuant to the impugned Annexure 16 order dated 21/8/2003. The petitioner may obtain the certificate. So, my lord, a protection was given, a temporary protection of 2 months. That within this period, the appeal will be considered and he will not be disturbed, if not already released from the post. Then, Lordship will see, in compliance therewith, this is the order of 2003. The compliance came in 2013 at page 52. Means, my lord, the order was passed in the appeal. Page 52. It is dated 25th of July 2013. After 10 years, it was considered. Lordship will see the last second, my lord. All our similar facts have been stated in the para 1 and 2. I have perused the order dated 5/1/2006 passed in WPC 7928 of 2003. Although in the last line of the order, it is mentioned that the Director of Elementary Education will consider his case, but in the 9th line of the order, it is provided that he will prefer appeal before the Director of Secondary Education. It transpires from the order that the petitioner shall file appeal application before the authority, and accordingly, he filed the representation dated so-and-so, but no order is seen to have been issued on the appeal. Seen the report of the Inspector of Schools, Gwalpara, dated so-and-so, which is at page so-and-so. It is also reported by the Inspector of Schools that the petitioner has not received salary since August 2003. Considering the plight of the petitioner and considering the fact that this office did not take any prudent action to terminate his service, government may consider his case on humanitarian ground to regularize his service with prospective effect, with his representation of so-and-so is disposed of. So, on humanitarian ground, an observation was made that let the government consider his case for regularization on prospective effect. From this particular para, it transpires that the 2003 order by which his regularization was cancelled still remains valid. What they say that let the government reconsider.
He has been serving.
On serving part, I am not saying, regarding that order, I am saying, 2003 order still remains. Only the observation was that let the government consider on humanitarian ground whether he can be regularized or not. That too in prospective effect, that is after 2013, if at all a order is passed. That three order still remains. Now, 13, that is a communication where the government wrote to the Director of Secondary Education for submitting a proposal for regularization of service of so-and-so of the petitioner. Then again, 14 also similar line, the communication was made. And Director, he forwarded the proposal to the government. Now, since the communication is of 2014, Lordship will see they mentioned about Finance SIU department. So, to have the approval of Finance SIU and to regularize the service of the petition. Lordship will see the third line at page 54. Page 54 is a communication dated 20th of February 2014 With reference to the subject cited above, I have the honor to furnish you with a proposal for regularization of service in respect of so and so, along with finance SIU format 1 and 2, and creation number so and so, by letter so and so so and so. So, my lord, the proper proposal was, at least, my lord, by this letter it appears, my lord, proposal was finally submitted by the director to the government in the SIU format. That format, lordship will find at page 55, next page. Post has been, my lord, mentioned, and this is the proper format, my lord. It was furnished, rightly or wrongly, it was furnished. Now, my lord, though it was furnished, nothing was done. So, in 15, my lord, the petitioner again approached the honorable. Page 57. Now, see, will see.
So the comment of the SIU department is justified and essential.
It is essential, my lord, because post July 2005, SLEC is not there, so now it is SIU. So they, in proper time, they submitted a proposal. It appears so. But, my lord, for non-consideration of that proposal, the petitioner approached the honorable court. That is WPC, my lord, 4511/2015. Lordship will see.
Where is that order? His proposal was not considered by the government. Where is
Yes,
that?
lordship will find page 59.
59.
Yes. 4511/2015.
No, that is the order in the writ petition.
Yes, my lord.
The order of the government for non-consideration of the.
No.
proposal.
It was pending before the government. So he approached the honorable court, praying for a direction to the government for considering it that particular proposal.
Okay.
It was not rejected at that point of time. Page 59, there is a final order passed. Page 60, my lord, the relevant part. In view of the above submission, present writ petition is disposed of with direction to the respondent authorities, more particularly respondent number 1. It is the, my lord, government in the education department, to examine the said proposal as submitted by the Director of Secondary Education Assam for regularization of service of the petitioner so and so. Lordship will kindly mark this part, my lord, in accordance with law. It's not a mandamus said that regularize him. The honorable court said that you consider it in accordance with law. So that in the event the petition is otherwise found entitled and eligible, necessary benefit of regularization may be given to the petitioner. This is an order passed by the honorable court that you consider it as per the law. And if found eligible, only then the regularization order is to be issued. It's not that, my lord, directly and mandamus was issued that you will have to regularize it. This order still stands, my lord. Now, my lord, pursuant to that, finally, the lordship will see, my lord, thus I will refer to page 61, there is a communication. 62, there is a report. And 63, this is a view of the view was sought for from the judicial department. Their legal view was sought for. 64 is the view of the judicial department. Last parameter, since admittedly service of the petitioner was not dispensed with and thereby made him to work for a prolonged period more than 20 years and therefore non-consideration of his case would cause great injustice. However, there may be legal difficulties in regularizing his service as proposed. Therefore, the department may consider to adjust his service against the proposed sanction post, and there may not be any difficulty since post is available and there are numerous instances of such adjustment of service of honorary teachers in Assam. Accordingly, the department may consider his case for adjustment prospectively on humanitarian consideration as proposed, and this may be done in substantial compliance of the honorable court's order dated so and so. Again, my lord, it says, my lord, in substantial compliance of the order dated so and so, that is at page 59. That in accordance with law, if found entitled. Now, page 65 is the, my lord, view of the finance department, which is impugned in the present litigation. Because that SIU will, my lord, and all will have to be considered. Finance department observes that under what provision of rule or act the education department has submitted his proposal for regularization of the service of so and so who has been illegally appointed. So finance department expresses his inability to consider the proposal. So and so is communicated. So, my lord, this is the final, my lord, decision now, my lord, of the government that, my lord, he cannot be regularized because, my lord, the initial engagement itself was, my lord, bad in law, was illegal. Without following the, my lord, due process, without following the, my lord, provision laid down in the rules for recruitment of, my lord, regular teacher, he was appointed and subsequently adjusted. And again, my lord, that particular regularization was cancelled in 2003, which still stands, my lord. All this, my lord, initiative that has been initiated by the government was only on humanitarian ground, not on legal grounds, my lord. And in fact, my lord, in the order at page 59, the Honorable Court itself has said that you consider him as in accordance with law. And if found eligible, he is to be regularized.
No, this is your own document, the note of the judicial department, where it is stated that admittedly, service of the petitioner was not dispensed with and thereby made him to
No,
work
my
for
lord, that part,
for more than 20 years.
yes, that part, no, we are not disputing. Cannot dispute, my lord, because, my lord,
No,
presently
now
also probably is.
can you say that having utilized his service for more than 20 years, now you can argue that his appointment is illegal?
No, illegal part, my lord, in 2003 itself, it was, my lord, considered. So it was immediately, my lord, after the adjustment in 2001.
Who committed the illegality? The additional secretary of your government?
That part, my lord, in this litigation, I cannot
Now the
make a
question
submission.
is, can you argue against your own order?
No, finally, my lord, it was cancelled, my lord. It's not that, my lord, that order remains. It was corrected. Whatever error appeared, my lord, in that particular decision for adjustment, it has been rectified by, my lord, cancellation order of 2003.
There is an observation of the director of the elementary education department and
Well-
also the endorsement made by the judicial department in favor of the petitioner.
My lord. Because, my lord, page 41 is very clear, my lord. This is the order dated 21st of August 2003. Lordship will see, my lord, the order. In view of the above finding, the order of adjustment of service of so-and-so is hereby cancelled. So 2003, it was cancelled. The Honorable Court said that you keep him in service for another 2 months. And in between, my lord, that appeal is to be considered. That order was passed in 2006. He immediately preferred an appeal as per the, my lord, liberty given in this particular order. And this particular order is not under challenge in the present petition, my lord. It has not been set aside by any court of law. Lordship has got what I am saying, my lord. It will have to be because this order stands as on date. Finally, the finance has said that no.
But at the same time, it has to be remembered that you have been utilizing his service.
No, whatever it utilized, my lord.
Why he should have not been discharged earlier?
My lord, that order, Lordship will see, my lord, now of 2006, page 48. It said that you within 2 months you consider, and my lord, you take a decision. If you want to keep him, you will keep. Otherwise, he will be released. That is the order at page 48. Now this compliance finally.
Admittedly, Mr. Gogoi, admittedly, you have utilized his service. You have utilized his service for more than 20 years. You pay the salary for 20 years along with interest at the rate of 9%.
Interest part, my lord, illegal appointee, my lord, how we can claim for a salary? After all, it's public money, my lord.
Yeah, why you have not discharged him?
My lord, this order at page 48, page 48, it says that you consider the appeal within 2 months. Until that time, not to disturb him. If he is not been released in the midway.
After what prevents
Yes,
you
my lord, no,
from
lordship will see,
discharging
my
him?
lord, in 2013, the order was complied. So, my lord, he continued. That 2 months continued, my lord.
Who is
2006.
responsible for the same?
No, my lord, I am not, my lord, commenting on that part. But
Okay,
this
okay.
record speaks, my lord, otherwise.
Okay. Pardon me, sir. A.R. Bhuya, learned counsel for the petitioner, and Mr. Gogoi for the respondent. Argument concluded. Judgment reserved.
No, my lord, I will pay some judgment in this regard.
What judgment?
Yes, that illegal, so far as the illegal appointment part is
Many
concerned.
judgments are there. We'll see. You furnish it to the court master.
Yes, my lord. That, my lord, citation, my lord, I have already provided. I will give the paragraph, lordship may kindly.
Uh-huh.
confirm that. Because one judgment says that, my lord, even for contractual appointment or ordinary worker or casual, whatever be, without following article 14 and 16, no such appointment can be made.
Who will say?
Even for consideration for regularization. I will give the paragraph, my lord.
Okay.
My lord.
Lord, I have already given one judgment. Only I have relied only one, my lord. It is on record, my lord. That's.
So, my lord, that part I can, my lord, differentiate, my lord. So, for the Jaggun.
No. Jaggu.
That
is Jaggu, my lord.
Furnish a copy to him,
My lord,
marking the paragraph.
Sure.
Yes.
Well, that part I can differentiate, my lord. The one, my lord, my learned friend is relying upon. That, my lord, recent judgment, Jaggu versus something.
It is the, my lord,
Yes,
regarding.
In that part, my lord, there is a specific observation at para 21.
Exploitative
No, no,
engagement.
that part, those words cannot be, my lord, now
Now they have,
imported in this particular case.
my lord, my
Must
learned
be The
friend,
nature of the case, my lord.
my learned friend's official says exploit my, my lord, more than 25 years, my lord. Now they want to throw me out.
And my lord, lordship will see, my lord, in that judgment, those are sweepers, my lord.
That is
We are
correct.
dealing with a teacher, my lord,
No,
not
no, that is
sweepers.
correct, my lord. That I have,
No,
I
no,
have.
no, that exploitation will not come in the case of this particular
Exactly,
case.
similar ratio of law will cover, my lord.
No, no, no. Ratio, my lord.
My lord can examine.
Yes, yes.
Citation to court.
Okay, you,
Yes.
Mr. Gogo, you go to the same.
Yes,
Mark
my
it
lord,
and, inform the court master.
Yes, ma'am. I will give the paragraph, my lord, that I will be relying upon in this particular judgment.
My
lord.
obliged, my lord, highly obliged.
Yes.
Obliged.
Next item.
Item 34. Item 34.
My lord, the sole respondent, Krishna Tarjari, he was appointed as the sole executor for granting probate in favor of Jaro Narjari. Jaro Narjari claims to be the second wife of Nivaran Narjari. Now, Jaro Narjari's first wife is Shashi Mohan Brahma. The first husband is Shashi Mohan Brahma, sorry, man. Now, Shashi Mohan Brahma died after 3 years of Nivaran Narjari. Now, when the husband of Jaro Narjari was alive, at that time she claimed that Nivaran Narjari is my second husband. Nivaran Narjari is I am Nivaran Narjari's second husband. So in that manner, the Nivaran Narjari, this person was lying in bed, and taking his.
Mr. Mahmood,
My lord.
we admit the appeal. Let notice go at this sisters. We will call for the record.
And while we have filed an IA, because there is a very serious legal question is here.
That's all right. We will issue notice in that IA also. Or
And
Mr. M. Mahmood.
my lord, interim order may be considered the next that.
Next that, okay, all right. This appeal.
Status quo, my lord, may be maintained. Otherwise, if the execution case is filed, the purpose of filing.
No, whether any execution case is filed.
No.
You are not sure.
No, not yet filed, but it may, it may
Okay,
be
we
filed.
will see, we will see.
Because unless there is an stay, they may file at any time.
They may file it.
So, my lord,
Then,
status quo on today,
No,
that may kindly be ordered. Otherwise,
this
my
appeal under section 229 of the Indian Succession Act 1925 is directed against the judgment dated 10/6/2025 and decree dated 10/6/2025 and decree dated 2/7/2025 passed by the learned district judge proprietor in testamentary suit number 1 of 2022. So we noted here that by the impugned judgment and decree dated so and so, the learned district judge proprietor in testamentary suit number 1 of 2022.
IA number 2247.
Granted probate of the will. Probate of the will. Dated 28/4/2025, open bracket, exhibit 1. Exhibit 1. Peruse the memo of appeal and the grounds mentioned therein, and also peruse the interim judgment and decree dated so and so. Admit. Issue notice to the respondents, returnable in 4 weeks. Step be taken by registered post with AD and also by usual process with a week from today. All further record from the learned court below. Please the matter after 4 weeks in IA. Heard Mr. Mahmood, learned counsel for the applicant. This interlocutory application is deferred by the applicant for staying the judgment dated 10/6/2025 and the decree dated 2/7/2025 passed in testamentary suit number 1/2022. Let notice be issued to the respondent, returnable in 4 weeks. Step be taken by registered post with AD and also by usual process in a week from today. This is on the draft of 4 weeks. Mr. Mahmood, if they file the execution case, you mention the matter, we will see.
35.
minutes.
Yes. Today you are equipped with the file?
Yes, Lord, sir.
Okay.
That day it was immediately after the vacation, the juniors were not there, Lord. Lord, sir, we have filed this appeal on the
What
ground.
is the ground?
Lord, sir.
What is the ground?
Ground that the vehicle was not involved. We had given evidence to that effect, Lord, sir. There's some reasons to believe that it was an implanted vehicle. The FIR, police case, GR case were all against one unknown vehicle and one particular person, Dhaniram Dole. The charge sheet has been filed against one Suraj Bite person. I could not make out a logical Lordship. In fact, Lordship, the GRK FIR was registered on 21st of January.
But the charge sheet was submitted? Submitted.
Submitted. Insurance company had contradicted that point.
After investigation, police submitted charge sheet in the police case.
Yes, Mr. Police Lordship, what remains a little on
whether
21st of January, the FIR was registered and GR case was also registered. On 22nd January, they seized the, it doesn't appear that, on the very next day, they seized another vehicle, another person. And MBI took again 5 months to be. Some reasons to believe not admit this appeal and hear this. I'm not pressed for us the immediate.
Heard Mr. Ardosami, learned counsel for the appellate. This appeal under section 173 of the MBA is directed against the judgment and award dated 27th of March 2025 passed by the learned member MSCT Lockingpur, not Lockingpur, in MSC case number
12 of 20, Lordship.
2020. It is to be noted here that by impugn judgment and award dated so and so, the learned tribunal has directed the appellant herein to pay a sum of rupees 23,42,855 rupees, being the compensation to the respondent number. Respondent number 1. Peruse the memo of appeal and the grounds mentioned therein. Then also peruse the impugn judgment and order dated so and so so and so. Admit. Let notice be issued to the respondent, returnable in 4 weeks, that be taken by registered post with AD and also by usual process within a week from today. All for the record from the learned tribunal, this is the matter of 4 weeks. IA issue notice. IA, if taken, heard Mr. Goswami, learned counsel for the applicant. this interlocutory application is referred by the applicant for staying the judgment and award dated 23rd/7/2025 passed by the learned member MSCT Lakhimpur in MSc. Certificate date case number 12 of 2020. Let notice be issued to the respondent, returnable in 4 weeks, that be taken by registered post with ADN also by legal process. Within a week from today, let's suffer 4 weeks.
Till that, interim, Lordship.
You have to
Till the next day.
50%. Are you ready to deposit the 50%?
Lordship, subject to indemnification bond, Lordship.
Pardon?
Subject to indemnification bond, Lordship, I will deposit it.
Okay. Later on, Mrs. Usami Samit said, the applicant herein is willing to deposit 50% of the awarded amount before the registry of this court. Taking note of the submission of Mr. Usami, learned counsel for the applicant, the impugned order dated so and so, impugned judgment and award dated so and so stands state till disposal of the MSc appeal number so and so. Subject, however, to depositing 50% of the awarded amount before the registry of this court within a period of 4 weeks from today. In terms of above this, I stand disposal.
So items under order 41, rule 2 CPC, item number 11, part third matter.
Lordship, we are the plaintiff's appellants. Our suit was dismissed, appeal was dismissed. Here we have come, by this appeal bamboo, we have filed another affidavit in the affidavit. By way of, we brought 3 documents filed by the defendants to rely upon these documents on which we can establish our title in respect of the suit land. So in the last learned trial court, we filed our evidence on affidavit. In our evidence on affidavit, we clearly mentioned that we exhibited Exhibit 1, certified copy of the Jamabandi of Schedule LM, Exhibit 2, copy of the revenue paying receipts, Exhibit 3, copy of the mutation or notice. But in dictating the judgment, in deciding the suit, the learned trial court at page 32, at first 32, on the last, in the course of the trial, plaintiff examined 4 witnesses, whereas the defendants examined 3 witnesses. Plaintiff did not exhibit any documents, whereas the defendants exhibited some documents. My submission in this case, there should have been an inquiry. If we have said in our affidavit, in our written evidence on affidavit, that these are 3 documents we have filed, specifically we have stated Exhibit 1, 2, and 3. While letting the judgment, it is shown that there was no document. So there should have been inquiry calling by these advocates of that plaintiff advocate. Yes, show me the documents. It is not there. So therefore, in appeal also that was not taken up. Now we therefore file this our affidavit for bringing up 3 documents which they relied. They relied 3 documents. That is their Exhibit A, B, and C. Exhibit A pertaining to the CETA copy, Exhibit B, Jamabandi copy, which we wanted to reflect in our Exhibit 1.
Mr. Bhagavati, your affidavit is dated 13th of June 2025.
Lordship.
So there you have mentioned only about Exhibit A and B.
A and B.
You have not mentioned C.
C, actually, that is that order. C, it is not a very important one. We say that we like to, if this honorable court rely upon the Exhibit B or Exhibit B, which
documents were marked as exhibit before the trial court.
Yes, Exhibit A, B, C. But ours we've exhibited as Exhibit 1, 2, and 3. That was marked. That is in our written evidence on written evidence. It was clearly stated marked.
Where is that affidavit?
It is that affidavit. We have that copy.
Page number.
Oh, Lordship, that is not there in that record, because in that case, the record has to be called for. My submission.
No, you have certified copy?
We have certified copy. We have certified copy. in the evidence of PW1.
And the same documents that they have marked as
As the exhibit
A, and
B,
C.
exhibit B. Exhibit B, even exhibit A and B. Exhibit A, in the exhibit A, our name was stuck up in one respect of 3/17 Lassa. In exhibit B, we had two document to we exhibit 2, it is seen that we are the owner of 1 bigger 2 kotha. It was 2 entries are there, 2 entries 3/17 Lassa, 3/17 Lassa. Our name was mutated in this by 5 order dated 28 or 28, 26. It is in our appeal memo I have stated very clearly. In our exhibit appeal memo, in appeal memo, that is down number at page 7. At page 7. That is your 4. For the exhibit B, Jamamandi exhibit D, their document. It is clear that 29/6 to 99, the name of plaintiff number 1 was recorded in respect of land measuring 3/17 Lassa. And in the Suddak and Patta, height order dated 29/8/99. The name of plaintiff number was recorded in respect of remaining 3/17 Lassa. In the said that, this is the true. But during the pendency of the said suit, the name of plaintiff number was struck off from the one entry of the in respect of the part of suit land measuring 3/17 Lassa. Even otherwise, even if it is struck off by when the suit was pending in the year 2010, 3/7 remaining 3/7 Lassa, my name is there. Secondly, at that time, relevant time, when the defendant number 2, respondent number 2 in this case, transferred the sale land, suit land in favor of defendant number 1, that is respondent number 1, he did not have saleable right on the basis of this exhibit B. He did not have saleable. He had land in other DAG, not in the suit patta, suit DAG. The suit DAG is consists of this. That is your patta number 79 and DAG number 1258. But as per exhibit B, respondent number 2, his name is Tomijuddin Ahmed. Tomijuddin Ahmed, he had saleable land in DAG number 1030, not 1258.
You tell me one thing. Though the learned tribunal, learned trial court in the interim judgment has stated that the plaintiff has not exhibited any
documents.
any document.
My submission.
But the fact remains that same documents were exhibited by the
Defendants.
and the learned trial court has considered all those documents.
Learned trial court has considered, and he considered one more thing. That is a cell deed. Cell deed, she relied heavily on the cell deed only. Cell deed, yes. Cell deed was executed, shown to be executed by a person who did not have saleable right at the right point of time. Therefore, when the person, the vendors did not have saleable right, how can the cell deed become under section 54 of TPA can be relied upon? Therefore, my submission at this stage, the cell deed does not carry any value. Yes, I have only Jamabandi, whatever right I have, it is only on basis of by Jamabandi. It is the, again defendant's right that they had only right only basis on the Jamabandi, nothing more. So these Jamabandi, they relied upon, we relied upon. Therefore, my submission at this stage on the point of our, what is that called, this substantial question of law, we like to only the purpose finding. The purpose finding is one. Second is that our D point at page 10. At page 10. Whether the decision of the learned trial court and the first appellate court are sustainable in law, given that the learned courts below relied upon the entry of the Jamabandi exhibit B in favor of defendants, but failed to consider this entry available in exhibit B in favor of the plaintiffs. One. And second is the purpose pending. This alone will do. If exhibit B, on the basis of exhibit B, which they exhibited, by right, I can establish by right. There, in that case, that this, I pray before this honorable court to admit this appeal call for the records. Yes, what is your submission?
Lordship, what stated by my learned friend, but my humble submission is not correct, Lordship. That's because in the additional affidavit filed, when the court declined to admit this appeal, he filed this additional affidavit. And this affidavit also, he has not placed the correct fact, Lordship. Also, kindly come to paragraph 2 of the additional affidavit.
Paragraph 2 of?
Or the additional affidavit filed by him, Lordship, here he is not given the date to the copies furnished. Additional affidavit filed by the appellant's Lordship.
Paragraph number?
Paragraph number 2, Lordship. That the deponent begs to state that the document exhibited by the respondent defendants, that is exhibit A, CITA exhibit B, Jomandi clearly shows the right title and interest of the applicants. A document submitted by the defendants and the right title comes from him. That filed order that the 29/6/19 and the name of the appellant number 1, plaintiff number 1, recorded in industrial and measuring 3/4 70 letters in the suit letter. But both the courts below failed to consider this important aspect and event on the basis of exhibited document by respondent defendants, not from his documents, Lordship. The right title interest of the appellant can be proved. Therefore, it is necessary to consider these documents by this court during the admission stage. Lordship, if come to the documents annexed with this affidavit, Lordship will find his name was recorded on 26/99 in the CITA mutation. But that CITA mutation was subsequently cancelled by the Revenue Authority by drawing up a regular proceeding. Lordship will find at Annexure A, note co. Filed order that 31/5/2000 passed by the sub-division is Rongia pass in miscase number so and so. Mutation granted filed order the 29/6/99 is set aside. So where is his name? He filed a title suit claiming right title interest, Lordship. So he has no right title interest. So how he will get the decree on the schedule billion, Lordship? It is his burden to prove before the court to his right title interest. But he could not produce any documents, Lordship. His suit before the court was there.
No. If we go by the affidavit filed before the learned trial court, it appears that he has exhibited 3 documents.
But here also he has not stated that he exhibited 3 documents, Lordship.
Right.
In this additional affidavit, he only relies on the documents of the defendant. He has not stated here that he has submitted 3 documents.
Yes,
ABC,
sir,
Lordship, these documents were executed by the defendants.
The certificate copy he has produced before the court today, in the evidence on affidavit of PW1, 3 documents were exhibited.
Lordship may be given statement, but documents were, may not be furnished, Lordship, before the court submitted.
No,
Yes,
no.
because, Lordship, in the judgment, Lordship, at page 39.
So, you see, this is evidence on affidavit. Why should we disbelieve it?
Lordship, that is the statement.
Yes. Statement on oath.
In respect of Lordship, Exhibit 1 and 3. 1 to 3.
120.
Lordship. But the documents may not be submitted as because Lordship, if we go to the judgment Lordship at the page 39 of the trial court judgment. Plaintiff exhibit nil. Page 39. Plaintiff exhibit nil. So he may be given some statement in the affidavit, but he may not exhibit the document. If documents are not before the court.
If that is the position, then there would have been an endorsement of the trial court that though it was marked in the exhibit, but the same were not exhibited before the court. You see this affidavit?
But these documents are the part of this affidavit, and there is no document in this affidavit.
Pardon?
These documents, they exhibited these documents, Lordship. These documents should be the part of this affidavit, but they have not. There is no documents. 1, 2, 3, Lordship.
Yes, Mr. Bhagavati.
It's very simple. That is what is. If it was not there before the trial court at the time of writing the judgments, when it was specifically given on a vote, there should have been an inquiry that these are the documents you have exhibited, these documents are not there. Because the problem is that when we file petition for getting this copy, these copies were there. These copies were there because that was not marked. They did not like to give us the copies. Why? Because that in that case there will be faulted by the officials of this court. So my submission is that I don't like to go to all those controversy. I like to only say that my exhibit B, which they have exhibited, establishes my right title interest about the suit lab. So why the suit?
Mr. Bhagavati, it is the settled proposition of law that the plaintiff has to establish his own
prove my
case.
case. That is why by proof I don't like to go to.
Can you rely upon the documents exhibited by the?
Because in that case, justice will be in that case. What they have got it, the sale deed is shown to be executed when the person did not have saleable right on that at that point of time. His name was not there. I'll like to, let us come to the my affidavit. I'll like to show how my right comes. Lordship, there were 22 names, 22 names, 22 names. Patadars. These are later on document. Because this is Jomabandi. Initially, it was only Sita. Later on, the Jomabandi, when it was written down in the form of Jomabandi, it became final documents. In the document, there are 22 names, including Nur Sheikh 2 and mine was the last. Sayyid Yusufur Rahman, son of late Mahmud. And in that same page of Lordship, it is Annexure B, which they have filed. Annexure B, there are 22 persons' names
And
in respect of
your name is it?
Patadars.
Your name is it?
My name is at page number 28, page of serial number 22, Sayyid Yusufur Rahman. In the last Zo and Neo, order passed by Circle Officer 29/6 to 99 on the strength of sale in the name of Yusufur Rahman is mutated about the land measuring 3/17 lessa in that number 539 stroke 1258. Then again, second entry, order passed by Circle Officer in 29/8/99 on the strength of the sale and NOC in the name of Yusufur Rahman, mutated about the land measuring 3/17, that number 539/1258 in place of Patadars number 6789. Now this thing is there. This is the document they have relied upon. At that time, the suit tag is a 1258. In the suit tag 1258, let us come to the first page again. His name is Tomijuddin Ahmed, serial number 4. Serial number 4. His DAG number was he's the owner, no problem. But his DAG number is a 1030 in respects of 2 bigger 4 kota 11 lessa. So he did not have saleable land in DAG number 1258. So sale deed executed by him in favor of sale defendant number 1 is not maintainable one, because it is that at that time without having right, sale deed was executed. So therefore, this is the document the landed trial court, appellate court considered in dismissing my suit, in dismissing my appeal. So therefore, I am relying upon their document. Even of my documents are not being allowed. Even if their document establishes my right over the suit land. Therefore, my submission at this stage that in the second appeal may kindly be admitted.
We will examine the matter. Yes, Mr. Soma, you furnish the copy to the court master. That affidavit.
Oh, affidavit. My affidavit.
Yes. But Mr. Bhagavati, learned counsel for the appellant, and Mr. P. Sarna, learned counsel for the respondent. Order is set.
Item 12.
Yeah,
Here, for commentator, we have a medical vehicle attention regarding this. Mr. Alam is not recovering well, so we have certain difficulty for this.
No, next that is fixed on 28 for execution. Then
Lordship, Mr. Alam has been really is going on a medical attention. So that is why we have not a medical document. Lordship, we are having that difficulty also. Otherwise, there is no problem.
Pardon?
We are having that difficulty. That's why we are praying for this.
Lordship may admit the appeal, my lord, call for the records, my lord. Within a month, it will be disposed of, my lord. It will be listed for admission hearing, then it will be disposed of, my lord.
The effective order can be passed after.
Because, my lord, your lordship may admit the, my lord, the second appeal. Lordship may call for the record, formulate the substantial question of law. My lord, substantial question of law, I have, my lord, stated. Here, my lord, your lordship will find, my lord, is a suit filed by one of my brother with regard to the ancestral property left by my father. My lord, 3 bigger 2 kata 5 acres of land. My lord, now the learned trial judge, my lord, said, my lord, first of all, the land purchased by the father, my lord, the predecessor, that has not been proved. So title of the Pattadar, original Pattadar is not there. It is not proved. Number 1. Number 2, my lord. Since it is a joint patta, my lord, suit patta is a joint patta.
So
My lord, at
where
page
is
ten,
the substantial question of law
At-
you have
at-
suggested?
at page 10, my lord,
Page
10. Without
this
making,
substantial question of law are not part of the your memo of appeal.
it is, my lord, it is, it is a part of record, my lord, but it is
Part
not,
of record, but
yes,
not
but
part of memo of appeal.
it is not there, my lord. My lord,
There is
we
a
may,
mandate of Supreme Court that it should be
that's
part
true,
of.
my lord. 103 also says so.
Then
Section 100 subclause 3 also says so, my lord. But here, my lord, we can say, my lord, grounds of the substantial question of law, my lord.
no,
My
Mr.
lord, we went
Mr.
there,
Sen,
my lord.
on earlier occasion, we did not consider the same. So if we consider in your case, then the other parties will take it otherwise.
My lord, can we make
When the
necessary,
next date is fixed, 28,
my lord,
28.
what is the next date?
Execution next date is on 7th of August.
7th of August, my lord.
7th of August.
7th of August.
Next date.
Next
Next
date.
date.
Before that, you filed the amended memo of appeal. Can you file it by tomorrow? Then we can take it up day after tomorrow.
Lordship,
Yes,
Lordship,
Yes,
we have already, they can file it, there is no hindrance about it, hesitation about it. But at the same time, we have already had under medical attention. But tomorrow, it again difficult for us, Lordship, because we are
Day
paying
after
for,
tomorrow.
Lordship, day after tomorrow. Again, because we are having the medical prescriptions and certificate,
That's
Lordship.
right, but we have,
Before 7th of August, any date can be fixed,
we
Lordship.
have given you sufficient opportunity.
Lordship, yes, we agree with it, and we are employed by it. Lordship.
Adjourn the matter for
Lordship,
indefinite period.
this week it will be difficult for us because he's under medical, really under medical attention, Lordship. And next, before the 7th of August, any date may be fixed for that. We are giving what Lordship. And in the meantime, they can file a memo.
my lord, the point is, now it is fixed for report. My lord, any day they may come and execute the decree. My lord. That is the only.
Therefore, we have list the
Yes.
matter today,
Yes, my lord.
but we
But-
find
but-
that
but
it is a
because
not
of
in
this
accordance with
difficult-
law.
Can we, my lord, make it necessary correction over here if you lordship permits, my lord? The ground, my lord, that has been
No.
stated, my lord. Can it be, my lord,
No,
made-
there is there is one notification issued by the registry. You have to go through the same.
my lord, that we have gone through, my lord. Now,
Okay,
we shall file our amended, my lord, RSA by tomorrow.
by tomorrow.
By tomorrow.
Lordship,
Let the matter be
Lordship,
listed by day after tomorrow.
Day after tomorrow, again, difficulty for us because
We'll see. Earth Mr. Assertion, learned
BK Sharma.
PK Sen, learned counsel for the appellant, and also Earth Mr. Bhatia, learned counsel for the respondent. It appears that the suggested substantial question of law at page number 10 of the memo of the memo of appeal is not part of the memo of appeal. Page number 10 of the appeal is not part of the memo of appeal. And Mr. Sen submits that he may be allowed to file amended memo of appeal by tomorrow, and price for listing the matter day after tomorrow. Prayer is accordingly allowed.
Lordship, my humble prayer is, can it be later, after some time, Lordship, because
No.
again, it will be the same problem it will be getting for us, Lordship, because we have already filed a letter of absence today, Lordship. Again, it will be difficult for us, Lordship. We have filed a letter of absence, Lordship.
Given you time, you may remain.
Lordship, execution proceeding is on 7th of August, Lordship. Any date before that.
Sorry.
Any date before that, Lordship.
Day after 13?
If in the meantime the decree is executed, then
Yes.
Lordship.
Yes.
if in the meantime the decree is executed, then
Lordship, it will not be, because the date is fixed on 7th of August, Lordship. So
That is
that-
for
that
for
is not
filing the
my lordship.
report,
Yes.
report of execution.
So the day after tomorrow again will be difficult because
Maybe.
My lord, day after tomorrow. Highly obliged. my lord.
oh, plus.
Maybe. I have settled the judgment and decree of that quorum that is 5/11/24. Substantial question of law is at page 5, madam.
Yes.
Last question, madam, so for the substantial question of law number 2 is concerned, it was madam discussed so far, my petition filed under order 41/27 was dismissed, whether that can be assailed hearing. In this regard, madam, may I submit before lordship, before taking note of this particular substantial question of laws, I want to point out one, madam, paragraph of the plaint, which is the foundation of the respondents to file the suit for eviction of the present appellants. That is at page, my lord, 13. Page 12 may take note of that.
Page number?
Page number 12. Paragraph number 17.
So in page number 12, there is no,
Plaint, madam, part of plaint.
yes,
Part of
paragraph number?
17, madam, 17.
Yes.
From 5th line, madam. So for the right title interest and possession they have stated subsequently, but the defendants firstly flatly denied vacating the position in favor of the plaintiffs from the suit land on so and
From
so.
where you are reading? Line number?
Line number 5
From top or bottom?
from top, my lord. So for my lord, second paragraph number 17 is concerned from top. 17 of the plain. Page number 12.
Therefore.
But the defendants flatly denied vacating the position in favor of the plaintiffs from the suit scheduled land on 27/10/2024, 2014. Therefore, the main defendants are the mere trespasser of the suit scheduled land, and hence they are liable to be evicted therefrom. Hence, the plaintiffs have compelled to file the instant suit. So, this statement has been firstly mentioned in paragraph number 15 when the cause of action has been arose as regards to their disposition. Page 15, that is the page 11, madam. Paragraph 15, page 11, madam. Line number, my lord, 4, my lord.
Page number 15.
Page number 11, paragraph number 15.
Yes.
Line number 4, my lord. But suddenly on 25/4/2014, the main defendant number 1 to 6, along with their some fellow men, entered into the Schedule A schedule land and illegally and forcefully disposed the plaintiff number 3, namely so and so, so and so, so and so. In such manner, in each and every persons, they have stated that on 25/4/2014, the plaintiffs have been disposed by the defendants. And subsequently, when they have asked us to vacate the suit land on 27/4/2014, we flatly denied, and accordingly, lordship may then turn to the relief sought for it in the suit. 14. Paragraph number, page number 14. Relief number D. Decree for declaration that on 25/4/2014, the main defendant number 1 to 6 illegally and forcefully disposes Schedule A, 1 land, schedule land, and the main defendants number 6 to 7 illegally and forcefully disposed B1 schedule land, and the main defendant number 9 and 10 illegally and forcefully disposed schedule C1 land, schedule land, and the main defendant number 11 and 12 illegally and forcefully disposed D1 schedule land, and the main defendant number 7 illegally and forcefully disposed schedule E1 schedule land, and hence the main defendants can be treated as the mere trespasser of schedule A1 so and so so and so. A declaration has been sought for that on particular date, the plaintiffs have been disposed by the defendants, and accordingly we be treated and declared as a trespasser. Now, basing on this statement, my lord, this has been the foundation of filing the suit, my lord. Now, substantial question of law 2 relates to this part. When there is no cause of action, they fail to prove the cause of action, my lord, whether the suit lies. And in relation to their position, they fail to prove. And we have specifically mentioned that we have been in possession, even my lord, prior to their predecessor, from the date of their predecessors. Now we have filed the application under Order 41, Rule 27, bringing on record a particular document of the government which discloses our possession, which is vital in relation to the decree which has been sought in relief number 2D and the statement made by the plaintiffs as made in paragraph number 15 and 17, which is the foundation of the, my lord, their relief and their approaching the civil court for seeking the specific relief against us for our eviction. Accordingly, my lord, so far, in absence of, my lord, the proof that they were, that is the rational way, not disposed on 25/4/2013, the issue decided by the learned trial court as well as the appellate court in that regard is silent, my lord. Because, my lord, so far the issue number 5 is concerned, it is specific that on 25/4/2013, whether the plaintiffs were disposed by the defendants. But to that aspect, the learned trial court was silent as regards to that particular issue. And that has been continued in the appeal of Sunan. Now, my lord, the situation is such that if that being shown, there should, in fact, be seized by the law of limitation for seeking recovery of possession. That is a substantial question number 4, my lord. Page 27 is the issue framed by the learned trial court. Issue number 5, page 28, connects with whether the main defendant number so and so or from forcefully disposed on 25/4/2014. Every lordship got it. Now, a decision arrived at by the learned trial court will in relation to the issue number 5 is at page, my lord, 36, my lord. Nothing has been stated as regards to, my lord, findings of the learned trial court below against the issue number 5.
By the learned appellate court.
Learned appellate court also silent, which is page 76, my lord. As regards to my lord, issue number 5, which ought to have been discussed by the learned appellate court, because the learned appellate court ought to have discussed each and every issue while dealing with an appeal matter. Page 74, you lordship, sorry, not 76, 74, my lord. Paragraph number.
No, the learned appellate court may not formulate any point for determination, but whether there was any discussion on that point.
No, my lord. So far, disposition part is concerned, issue number 5, there is no such, my lord, clear findings, either from the trial court or from the learned appellate court. Starts from, my lord, paragraph number 60, page 74. It is the decision point for determination on the issue, but if whether the learned trial court had rightly decided the issue number 5, 7, and 8, wherein the learned trial court.
No, you come to page number 36 of the memo of appeal.
36, my lord.
Yes.
36 is the, my lord.
There the learned trial court has discussed the issue number 5.
Issue number 5, 7, and 8 is there. my
Yes.
lord. So far, my lord, the findings of the learned trial court below as regards to issue number 5 is concerned, my lord. That is not there, my lord. No doubt, my lord, discussion on issue number 5, 7, and 8 and jointly take altogether, my lord. But on reading of the, my lord, contents of that paragraphs, particular paragraphs, there is no such, my lord, conclusion of the learned trial court below as regards to issue number 5. On that particular day, they were disposed.
No, trial court has decided all the issues in affirmative.
My lord, all the issues have been affirmative, but my
This,
lord, so
your
far,
last line, hence these issues are decided in affirmative.
yes, my lord. May I read it? So far, my lord, reaching in a point, my lord, there must be some reason. Some discussion should be there. Why the learned trial court below has arrived at such point. That is not there, my lord. Simply, my lord, stated, decided apartment.
No. There was discussion in paragraph number 29, 20.
My lord,
30,
I am
and
reading.
31.
Then my, from 28, my lord, I am reading. So far, issue number 5 is concerned, which is related to issue number 5. The above issues being interlinked to each other are taken together for the convenience of discussion. From the decision in the foregoing issues followed by the elaborate discussion in the light of the evidence on record, it appears that the defendants are not legal heirs of righty khatian holders, nor they are claimed the right title interest through the original patra directly over the suit land. As such, it is candidly clear that they have no right title and interest over the suit land. During cross-examination of DW2 and DW5 stated that they know Schedule so and so land, which is occupied by defendant number 1 to 6, B1 land is occupied by defendant 6 and 7, Schedule C1 land is occupied by defendant number 9 and 10, Schedule D1 is land is occupied by defendant number 11 and 12. DW2 stated that he does not know who is occupying Schedule E1 land, whereas DW5 stated that Schedule E1 land is occupied by defendant number 7. It is admitted fact that the plaintiff number 1 to 3 have purchased Schedule A1 to E1 land by registered sale it from the rightful owners, whereas the defendant number 1 to 7 and 9 to 12 are occupying the said land without any right, title, and interest, however, whatsoever. As such, they are not only mere trespasser, but also liable to be evicted therefrom. Hence, the issues are decided in affirmative. Now, my lord, so for the eviction and disposition part is concerned, totally, my lord, not discussed. Not a single.
No, that
my lord, may I submit your lordship? The plaintiffs
Mr.
may.
Sharma,
My lord.
this is second appeal.
My lord, no doubt.
We are not supposed to appreciate the evidence.
My lord, no, that's true, my lord. But so far, when the foundation of the plaintiff, my lord, sued, and so far our
We
connected.
cannot decide whether the learned trial court and the
My lord,
learned
then-
appellate court
Yes,
has rightly arrived at this finding.
yes, my lord. This part,
Because to
Yes, yes,
arrive
yes,
at such a
lordship-
finding, we have to
lordship-
appreciate the evidence,
lordship is right.
which is not permissive.
Lordship is right. But my submission before lordship is such that when a suit has been filed and we have taken the plea of limitation, my lord, then if the plaintiffs fail to take the, my lord, or prove their position, and if someone possessing the land for some more years, which is are covered by the Limitation Act, then for recovery of that particular plot of land beyond the period of limitation, is the provision of law, which is I have mentioned substantial question of law number 4, my lord. Because they cannot do, my lord, original land, my lord, the owner, my lord, he did not file any suit within the period of limitation. Subsequently, he sold it out, and the new purchaser has filed the suit for eviction. But so for our, my lord, possession, long possession has come into play, whether that can be punishable under the Limitation Act. 4 is there, my lord. Because they have admitted that we are in possession. The document is itself stated that we are in possession. Now, if we are in possession, the question of disposition doesn't come, my lord. Then, my lord, they fail to show the why they have approached. And that too, my lord, so for eviction part is concerned.
Where that plea was taken?
My lord.
Limitation plea?
Limitation section, my lord, substantial question of law number 4.
No, in the written statement,
Written
where it
statement,
was taken?
yes, my lord. Page, my lord, 16, number 2.
Can you show me your affidavit?
That is my lord, written statement, my lord, our written statement.
No, that's all right, but you show your affidavit?
Evidence on affidavit,
Yes.
that is not, that may be record, may be called for, my lord, that will, my lord, appear everything, my lord. And
Pardon?
so for their admission part is concerned, that is also appear, my lord. And our evidence will, my lord, also appear from the record, my lord. That may be called for, my lord.
No, before admitting the appeal, we cannot call for it.
My lord. So
You
for
have
the
certificate
my
copy
lord,
with you.
I have, my lord, annexed the written statement, which I have submitted before the learned trial court.
But that's all
Which
right,
is
but
at
the
16, my lord.
affidavit, but the
My lord,
affidavit
so
is
far,
submitted there.
so far limitation part is concerned, is my lord, part of law, my lord. Limitation part is part of law. So if I assail that point, my lord,
No,
it need not be.
Merely mentioning it in your WS will not serve the
My lord,
purpose.
so far
You have to
limitation.
assert it by adducing evidence.
My lord, may I submit, my lord, one thing?
You produce that
So far limitation point is concerned,
affidavit,
only,
we'll see.
only, my lord, mentioning the seat. It can be
Whether that affidavit is with you,
that
not with you.
my lord, what happened, my lord? Actually, I have forgotten to take the brief of the. I am taking the brief of my brother, my lord. So far, evidence is concerned, I have found it in my record, my lord. But one thing,
You show me the evidence in affidavit, we will see.
So for possession, we can sue. One thing, my lord, I have filed one application for bringing on record as additional evidence. So far, my position is concerned. That is very much essential, and it is connected with issue number 4, substantial question number 4.
Okay, we'll consider that.
My lord.
You produce the evidence on affidavit first.
Day after tomorrow, my lord.
Yes.
Tomorrow,
Or Mr. M.K. Sharma, Lord, I talk for the collect. List the matter on Thursday. So as to can it be on next Monday?
My lord, execution proceeding is going on. My lord, that will, my lord, I have also filed. This is, my lord, going on, my lord. Otherwise, my lord, we will be addicted, my lord. It will be in another proceeding will, my lord, come, my lord, for restoration of possession.
Right. Then Friday.
Friday, my lord, I will be.
Friday,
sir, I have some difficulties, my lord. I will may not be, my lord.
Then Monday.
My lord, maybe on a Thursday or Wednesday, my lord, this coming Wednesday.
Thursday, already a lot of matters have been fixed. So on that day, your matter may not be.
Wednesday, it is not very. Wednesday in a time. Then maybe on Monday, man.
Monday. Take the matter on Monday, so it's to enable Mr. Sharma to bring on record the evidence and affidavit filed by the appellant before the learned trial court. list accordingly.
Obliged. It will be my lord pardoned, my lord. Obliged.
Here. Here. Yes, sir, Ahmed,
Hello.
it is about
I have framed substantial question over in several seat. Time is my lord.
let it be on Friday,
Tuesday, my lord. Tuesday, my lord.
next Tuesday.
Next Tuesday, 29.
Okay. Let's list the matter on Tuesday. That's it.
Obliged.
Other matters always. Better.
For orders.
I'm appealing for respondent number 1 to 4, Lordship.
Respondent number 1.
1 to 4. Lordship, kindly last order. Order dated 25/6/2025, Lordship.
None appears for the appellant on call. How about Mr.
D. Devi, Lordship.
Learned counsel for the respondent number
1 to 4.
1 to 4 present. Mr. Terry has drawn the attention of this court to the order dated 25/6/2025 passed by this court and submits that an observation was made that if on 21/7/2025 the appellant does not take step and does not appear, then the court will have no other option but to dismiss the appeal for non-prosecution. In spite of the aforementioned observation made by this court, the appellant remain absent and also failed to take any step, and therefore Mr. Terry is contended to dismiss the appeal. Having heard the submission of Mr. Terry, learned counsel for the respondent number 1-4, I have carefully gone to the order dated 25/6/2025 and I find sufficient force in his submission. It appears that on that day also the appellant remained absent appellant remained unrepresented, and also he has not taken any step. And today also the appellant remained absent, remained unrepresented. That day of the matter, this court deemed it appropriate to dismiss this appeal for non-prosecution. Order record. So rest of the matters, date can be taken from the court master.
Item number 25.
Still today, madam, that may be extended. Item 25.
Take it that from.
Well, interim may be extended, madam.
Same for item number.
The interim
24,
is there till today, madam. Item 25.
24 also same, my lord. The interim is till today, my lord. I'm grateful, my lord.
30. Item 30, I have a small prayer, my lord. Item 30, my lord, last occasion, the respondent counsel, I for the petition, the appellant herein, my lord. I have filed an application to construct my building in my own land. They have last time took up time to file objection. Till today, they have not filed. Neither they have appeared today. Very urgency is there. My land, I am in occupation, but I am not been able to construct my house. Very urgency is there.
My lord.
Okay, take a short date from him.
Not that, and item 30.
For sure, item
An
21.
interim order to
interim, my
continue,
lord.
my lord.
Item
Okay, you,
20.
mention your item number
Lordship.
and give and inform him
Lordship.
in which item the interim order has to be
Lordship,
accepted.
item 21 is
Item number 39, madam, maybe different.
yes, sir.
Lordship.
Obliged.